Court Uncut, what the people want.
Good morning, sir. You're Alfredo Gayton. And Mr. Gayton was previously in court in cause number 25 DCCR 0184, entered a plea of guilty to driving while intoxicated third or more, which was enhanced to a second-degree felony because of prior offenses. The agreement was for a cap of 14 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Your Honor.
Are there any additions or corrections?
No worries, Judge.
All right, Mr. Parker, you may proceed.
Just some of my client's knowledge. I've given the court and the prosecutor a letter of support from Frank Maida.
And I've received that and reviewed it as well.
And, Your Honor, from talking to this man, talking to people that have known him, he is a good person that's just an alcoholic. And I think he was, pretty honest in his PSI. He talks about drinking at the age of 11, then 14, and then get to the point where he drank, at least a 12-pack regularly. He drank tequila and Crown Royal regularly until the point where he passed out and could never get enough. He's had several DWIs in the past. He's never had any kind of help at all. And I think he is a prime candidate for safety to get the help. He's had some periods where he's tried to do it on his own, and he was somewhat successful. He cuts grass for a living for several people here in Beaumont. He has the ability to make money if he's given the opportunity to be put on probation and go to the safety program. So he can do that. It looks like to me that the PSI is also in concurrence that he would benefit from safety. And I just think that's the best thing for him instead of just locking him up.
Thank you, Mr. Parker. Ms. Malfino?
Judge, I think it goes without saying that he certainly could use the help of safety. I think it also has to go without saying that prior to the criminal history that cannot be ignored. Obviously, of course, we defer to whatever the court deems appropriate. I respect Mr. Maida's letter. I take him at his word. But it's just difficult for me to argue both ways because I think he needs the help, but I also think we have the criminal history to take into consideration.
And again, I think most of his criminal history is just drinking, and so many people have got the opportunity and it's worked for him, and he, not from anybody's fault, he's never got that help, It's okay. Is there anything you want to tell the court?
They sent me to prison and made me work and work and work. They never teach me how to stop drinking. And I always look for things. I'm always making this to proceed. And I'm working on the freeway. It's with Texas Department of Transportation, cleaning the roads, do anything. And disasters never give me a chance to stop.
But if you've gone to prison 3 prior times
Yes, ma'am.
for DWIs, 3 times you've gone to prison. So this is your 4th felony DWI.
Yes, ma'am.
This is at some point when you get out of prison, do you say, I need help and I'm going to get help for myself instead of saying somebody else didn't help me?
I never have a chance. I have to look for work.
But I know, but you have people like
Yes.
Attorney Maida. You could have said, hey, I need some help. You know people that can help me. I don't want to go back to prison.
Well, finally, this time I end up on the right city with the right people. Create a really good reputation. I met Mr. Maida, Dr. Suri, and a lot of good people, and they check my background, and Mr. Maida said my wife and me discussed, and we willing to give an opportunity. I've been working for them for years now.
I just to make more clarity, I think that when he came here and he was working for the people around here, there were some things that he was doing, and he was not drinking. I don't remember the incident, but there was an episode where he started drinking again, and it was pretty close to the time frame. This wasn't the. I'm not saying this is the only time, but he had started drinking again, and I don't take it that he was blaming anybody for not giving him help. He just said he's never had that opportunity. And when you're an alcoholic or a drug user or addicted to anything, it's easy for to say. It's the same thing with an abused woman. Why don't you just leave? Why don't you just leave? Just learn.
But
Stop
if you,
drinking. And
but you
it's
can,
hard. Yeah.
I don't disagree that it's hard.
And
But I also, if you'd never been to prison before,
right.
and if you hadn't had kind of the wake up call of prison to say, I don't want to go back to prison. I need to figure out how to stop drinking. And then you get out and then you do it again. Well, I didn't figure that out. Let me go
Right.
do it again. Your blood alcohol was 0.257. You ran off the road. You could have, I mean, there's just too many times that I see now, unfortunately, people in here where we're looking at someone who is, has killed someone or hurt someone. And the fact that this is your 7th DWI, it's your 7th. I don't disagree that you need help, but I don't feel like now's the time for, and I don't know what happened in those cases in Harris County and Bexar County. If you were given an opportunity, at some point, I feel like there's opportunities for probation where people decide not to do that because sometimes doing a few years in prison is easier.
Well, I
It's
think
odd to me that there has not been a probation.
I think some of these he sat in jail and wasn't able to bond out, and it's one of those deals. We'll plead you to 2 years or 4. I don't remember the numbers, but and so.
I mean, you got 12 years back in 2004. 12 years for your DWI, second felony DWI. Then you got another one after that, and for some reason, Bexar County said, well, let's give them less time. Let's give them 5. Let's reward them for continuing the wrong behavior. Anything else?
I mean, the same thing. I just see people that, it's, I concentrate solely on the fact that his criminal history is alcohol. And there are people that we've seen on their 4th or 5th that we've given safety to, or people that are on probation. People are on probation for DWI and they violate the terms of probation by drinking, and they come back before, all these courts, and several times we say, hey, let's give you safety, and I can make the same argument. You just went to court. I get it, but I don't get what people think. But I just think he's a prime candidate for safety, and he would benefit from it. He's a good person. He'll work. But I understand the court's position.
Yeah, sure.
I've been so
I'm sorry.
I've been sober since the accident. I moved to a small chair.
You've been sober since the accident.
I moved to a chair that is on the back of the property, Mr. Maida, and he said one condition, no drinking. And I respect that, and I've been doing exactly what he says. Because I know he's the only one of the few persons that believe in me, and he's here me a great opportunity. I know it's the chase.
I can't slow down.
He said he's one of the only ones that will give him an opportunity. He knows he's serious about. He's allowed him to move on the back of his property in a little room, I think.
We even went to what they call a retreat. He asked me if we need to go, and I said yes, sir. And we spent 3 days, and he's a great person. He's been helping me a lot.
So here's the thing. If I even were to consider, which I'm not sure why I'm even considering, but I might, giving you a probation, you would not drive ever a vehicle.
No,
it would be part of your probation. So you're going to have to,
I haven't get a car.
Listen to her.
It would be a condition of your probation that you never drive the entire time that you're on my probation. You understand that?
Yes, ma'am.
So,
Judge, if it would help the court, I'd be happy to try to get with the probation department and get with those other district attorney's office and see if there's ever been a probation on any of those cases that have been subsequently been violated.
I think they typically are listed in here that way. And so it doesn't appear that there ever has been one. I guess one of my dilemmas now is if I do consider probation, it would have to be a straight probation and only for the 10. And I lose that opportunity that I have today to give up to 14.
Well, you could
years.
possibly, one thing we could possibly do is sentence him to 10 over 10, give him 180 days up front and hold that in abeyance as a condition. I mean, which just extends it more. I mean,
Nah,
like a,
I don't know that it really extends the time. It just gives them time
Right.
potentially.
Yeah.
Okay. Here's what I'm going to do, Mr. Gayton. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to give you an opportunity today that you have not had, but there's going to be some conditions on this probation, and you will be on 0 tolerance. And what that means is that any violation, is going to get you right back in here with the sentence that I'm giving you today. I will make a notation. There will not be plea agreements on a motion to revoke your probation. If you violate and I find that you violated, that's it. You're done. Do you understand? So I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You're on probation for 10 years. I'm going to order as a condition of your probation that you enter and successfully complete the SAFE-P program, and that when you're released as part of the aftercare, you will then enter and successfully complete the JCDI program, which is an outpatient program. You will be ordered not to drive any vehicle ever whatsoever. You will also be ordered to wear at all times a scram device. That's a device that will tell me if you have alcohol in your system. If you test positive on that, when you get out after SAFE-P and you test positive for alcohol, you will immediately be back in here and go into prison for 10 years. It's that simple. It's the length of time that you have been an alcoholic. This is going to be a very difficult process, but either you want to do it and go through that difficult process, or you want to spend the rest of your life in prison. So that's going to be up to you. There's no, I relapsed and this is a difficult thing. And I understand that. This is it. You will be ordered to serve 10 days upfront time as a condition of that program. That's required. You'll obviously get that time in while you're waiting to go to SAFE-P. Anything else condition-wise that anybody can think of? I'm sorry. I'm going to order a $500 fine. All right, so I think that covers it. And so, Mr. Gayton, I hope you take advantage of this. It sounds like you're ready finally at this point in your life. I hope you take advantage of it because, again, this is the only opportunity you're going to get here in this court.
And thank you. Appreciate
Would we have any ability to pretty tightly monitor his no driving? I mean, I know that's just.
I don't know how to, because if I put, a GPS won't do it because if he's in somebody else's vehicle, I mean, I'm inclined to reach out to,
Maybe some of those people who have reached
yeah,
out for him.
so I'm inclined to reach out to Mr. Maida and explain to him
I will explain
about the no driving, because I know Mr. Maida is the one that helped get him that vehicle in the first
Right.
place that ended up, I think, part of this wreck.
Right.
But when I say no driving, it doesn't mean in a couple of years I get some request that, hey, he's been doing great, let him drive. You're either riding with someone or you're on a bike or whatever else or walking. And that is the most serious part of what I want and need to do to make sure that the community's safe. Do you understand?
Yes, ma'am.
Okay. I don't see the certification. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, Mr. Gayton. I hope you take advantage of this. Don't make me regret it, please. Okay.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.